are exempted from infantry combat and submarines today. Those differentials are there. Now, a very powerful Democrat today, Congressman Charlie Rangel, has got his bill to reinstate the draft. And, of course, it is sex neutral. I'm going to do everything I can to prevent his bill from passing. But if it passed, there is no question about the effect of ERA. It would treat women exactly the same as men, and women do not want to be treated the same as men in the military and in combat. Now, among other things that Ruth Bader Ginsburg says in this, and what she doesn't say, is it's going to have no effect on the Constitution itself, because the Constitution is already sex neutral. The Constitution does not say men are created equal. That's in the Declaration of Independence. Fortunately, you are not amending the Declaration of Independence. We're talking about the Constitution. And the Constitution uses exclusively sex-neutral terms. We the people, citizen, resident, inhabitant, president, ambassador, representative. Women have every constitutional right that men have. Also, this book makes clear that it has nothing to do with employment. It's not going to give women a raise or make them equal in the boardrooms or in the legislatures, because our employment laws are already sex neutral, and this book makes that clear. However, there are some differences, and one of the differences is the effect it would have on homemakers in this country. One of the most offensive things that Ruth Bader Ginsburg says in this book is that the concept of dependent wife must be eliminated from the code. Now, what does that mean? The Social Security system rests on the concept of the dependent wife. I'll bet I get my Social Security based on my husband's income over the years, and I'm sure that's true of many women here today. Social Security is a very pro-women institution because it gives the benefit to the dependent wife who was not herself in the workforce. According to Ruth Bader Ginsburg, that is a concept that must be eliminated from the code under ERA. This book was written to describe how ERA will affect federal laws. And then she goes into how it will change the words. When you say you can't discriminate on account of sex, and she gives a whole list of words that will have to be changed. And among the words that would have to be deleted from the federal code are husband and wife. Now, that is a direct attack on the Defense of Marriage Act, DOMA, which says that marriage is the union of a man and a woman as husband and wife. The feminists don't like that. They want to put us into a sex-neutral word, and certainly it would have a direct effect on the federal DOMA. She makes very clear that ERA would require us to treat basically sex like we treat race. That's one of their arguments, and it would require everything that is separated according to sex to be sex integrated. Now, she specifically says that this would include the Scouts. It's discriminatory to have Girl Scouts and Boy Scouts. They would have to be put together. She says fraternities and sororities would have to be combined. She says even prisons would have to be sex integrated. There's all kinds of mischief she has in this book under her name, in a book published and paid for by the U.S. government. She makes arguments I never dared to make, that it would wipe out the laws against prostitution and the laws against bigamy, that it would reduce the age of consent to 12. And she even goes after Mother's Day, because that would be sex discriminatory. Now we have, of course, it would, in the matter of marriage, it would open up the courts to all kinds of litigation by the gay rights movement, which is working very hard on every type of judge they can find to give them whatever they want to have. Again, the Equal Rights Amendment says you can't discriminate on account of sex, and that is what you're talking about. If you deny a marriage license to a man and a man, you have discriminated on account of sex. And all the highest legal authorities from Harvard and Yale have all said that the Equal Rights Amendment would okay same-sex marriage. I was on the platform with the great Senator Sam Ervin, considered then the leading legal authority in the Senate, the great Watergate senator, who said the only people who would profit by the Equal Rights Amendment would be the homosexuals. And you can have all kinds of litigation on that. On the matter of abortion, we know that the New Mexico case is very clear. The argument of the feminists is abortion is something that happens only to women. Therefore, if you deny any rights or any funding on abortion, you have discriminated on account of sex within the meaning of the Equal Rights Amendment. Now, we do not have 19 states with state ERAs. There are only 6 of the states that have ERAs in the same language as the proposed federal ERA. One of those is New Mexico, and that is why New Mexico said that it is discrimination to deny funding for abortion in New Mexico. Another one of those states was Hawaii, which is where they okayed the same-sex marriage based on the State Equal Rights Amendment. Hawaii had to pass another constitutional amendment saying, in effect, no, we didn't mean that. So there are all kinds of problems that come along, and I think it would move the whole area of family law to the federal government because of Section 2. Section 2 says Congress will have the power to enforce it by appropriate legislation. And there are all kinds of family property laws, divorce, child custody, that would then become federal matters under the ERA. This country wisely rejected it after long debate, and I think what it comes down to is how the judges interpret it. And we have no confidence. You ask for assurance of what the judges are going to do. We don't know what they're going to do. But in any event, I think the country made a very good decision in voting it down in a 10-year battle that went on all across the country, and I hope that we can leave it decently buried. Thank you, Mr. Chairman, for listening.
Thank you very much. And seeing no questions, we thank you for your testimony. I just want to remind you, we've got Elliot, you're recognized.
Thank you, Mr. Chair, and thank you, committee. It is my pleasure to be here today to speak on behalf of this resolution. I would think at some point I would get used to having to ask other people to recognize rights that I think I should have explicitly, and I think that's what this is all about today. And I want to start and try to be respectful. I've made some notes to keep myself on track here, Mr. Chair. But I was just really curious. About 9 years ago, I had the opportunity to go to Japan and do some educational exchange in Japan. And one of the things that we had to do, we had to study their constitution and so forth. And I dutifully studied, and I was just really, really surprised. And we've talked about this some today, looking at their constitution, that we require them to write, what we require them to put in their constitution regarding the issue we're discussing today. And I just want to read you specifically what we require Japan to put in its constitution. Peers and peerage shall not recognize, shall not discriminate on the basis of creed, sex, social status, or family origin. We require them to put in their constitution that there would be no discrimination on the basis of sex. In 1941, we did that. November 3rd, 1946, pardon me. And then on January 4th, 2004, here's what we required of Afghanistan, a country I think that you would recognize that probably is not considered to be the bastion of free anything for the most part. But this is what we say. The citizens of Afghanistan, whether man or woman, have equal rights and duties before the law. That's what we require of Afghanistan. And we mentioned earlier, somebody mentioned the Iraqi Constitution. I think Representative Harris did. And he read what's in the Iraqi Constitution. I will just remind you, here's what it says. Article 14. Iraqis are equal before the law without discrimination based on gender, race, ethnicity, origin, and so forth. And that, of course, was ratified October 5th, 2005. So here are 3 good examples of what we required of others and